My name is Daniel Vaswani, and I'm the lead attorney at Virtuoso Criminal and DUI Lawyers.
Today we're going to talk about second-time DUIs. What constitutes a second-time DUI is effectively that you've obtained another DUI arrest within 10 years of your first DUI arrest. That would make it DUI number 2. Now, keep in mind that DUIs have graduated penalties. When you pick up a first DUI, the penalties are less, and they make the second DUI more serious. The basic penalties for a standard second-time DUI are quite complicated. They could either mean, if you were to get convicted, that you'd be placed on probation for either 3 years or all the way up to 5 years. It could mean fines and fees and base penalties beginning around $390, which could result in a $2,000 penalty approximately. Of course, you'd have the opportunity to pay those penalties through a series of payments. Now, if you recall correctly from our first video, we explained that if you pick up a DUI, just a regular 23152, and you were convicted, that required a mandatory minimum of 2 days county jail. Guess what? As I said, on a second-time DUI, the penalties are higher. It's a mandatory minimum 10 days county jail. In most counties, it doesn't necessarily mean that you actually have to serve an actual jail sentence. What it means is that you potentially could qualify for alternative sentencing. More often than not, what it is the referral to the county's alternative sentencing program, which is referred to as either the Sheriff's Work Alternative Program, the Alternative Sentencing Bureau, the Alternative Sentencing Program, and usually that program will allow you to complete a series of tasks in 8-hour days, and that can satisfy the jail component. Keep in mind that the DUI school is actually longer than what it was on a first DUI. If you picked up a first DUI, your DUI school was either 12 hours, 3 months, 6 months, or 9 months. The mandatory penalties for a second-time DUI are actually an 18-month DUI school. It's quite a bit longer, quite a bit more expensive. And in fact, if you pick up a second-time DUI after a first-time DUI, and that DUI resulted in the death of somebody else, meaning you had a collision with either a person or a vehicle which led to somebody's death either within your own vehicle or outside of your vehicle. That can be a case where they actually charge you with murder. Now, it's much more serious and really important. Outside of that, a second-time DUI often brings point penalties with the DMV. At a minimum, if you're convicted, it will be 2 points assessed against your driving record. And in some situations, it can be more. You will also be ordered while on probation, like I said, it was going to be 3 to 5 years, to not drive unless properly licensed and insured, to submit to a chemical test when asked by a peace officer, and not to drive with a measurement of alcohol while on probation. In some counties, the court will also order you to abstain from the consumption of alcohol and not go to bars or other facilities where alcohol is the primary item of sale. You know what the courts are going to do or have an idea. And now we're going to talk about the DMV, because the DMV is a natural component with any DUI. The DMV has its own independent right to take action against your driver's license and impose restrictions by which to reobtain your driver's license if it in fact is suspended. If you are convicted of a second-time DUI, almost invariably, you will serve a suspension with the DMV. That suspension, if it's only a regular DUI, will be for a period of 2 years. But in most situations, you can begin driving immediately with installation of the ignition interlock device in your vehicle and keeping it functioning for a period of 1 year. You will also need to enroll in the DUI school, obtain SR22 insurance, and pay the reinstatement fee with the DMV. If you had a second-time DUI, which resulted in injury to a third party, meaning a passenger in your vehicle or somebody outside of your vehicle, then it's a 3-year revocation. Don't worry, you have eligibility to drive so long as you keep the ignition interlock device in your vehicle for a period of 2 years. Now, if you have a refusal on a second-time DUI, it's still a 2-year revocation. You may have to get ignition interlock device on your vehicle after serving a hard suspension. If you have questions about these issues, please give us a call at 8336 No Jail.